my esteemed colleague in the Supreme Court, Justice Ujjwal Buyar, the Chief Justice of Assam High Court, sister and brothers of the Assam High Court, the Advocate General of Assam, the President of the High Court Bar Association, senior advocates, members of the bar, and junior members of the bar who are present here in large numbers. The topic given to me is mixture of two topics. First is duties of lawyer under the Constitution of India. And second is art of advocacy. There is a correlation between the two topics. As far as duties of lawyer under the Constitution, duties of an advocate under the Constitution are concerned, I can sum up in two sentences. One is follow professional ethics to the hilt, and second is always take a stand within four corners of law for upholding the Constitution of India. I always tell the members of the bar, especially young members of the bar, that please look at the first clause of Article 51A, which enjoins every citizen to abide by the Constitution and to respect the ideals under the Constitution. I believe that if ideals of our Constitution are to be protected, the members of the bar have to play a very important role. When we talk about taking a stand, in the bar function, my esteemed colleague Justice Ujjwal Buyar referred to stand taken by bar associations in Maharashtra. They took a stand even to the extent of going that they do not have confidence in the integrity of four sitting judges of the Bombay High Court. There are instances and instances. I refer to Keshavananda Bharati judgment. Within few days of that judgment, 3 senior-most judges were superseded. On the very day in the morning, there was spontaneous reaction on the part of members of the bar. If I recollect correctly, former Chief Justice of Bombay High Court, M.C. Chagla, was the president of the Supreme Court Bar Association. Lawyers spontaneously met, the Bar Association met without calling a formal meeting, and they protested about the supersession. If independence of judiciary is to survive, it cannot survive without active role being played by the members of the bar. Of course, that responsibility lies on the judges also. As brother rightly put it, that we are final, not because we are always right, we sitting in the Supreme Court. And we are not infallible. And therefore you see the change of views between 1950 from A.K. Gopalan's case to Maneka Gandhi. We had traveled far ahead. And I always believe that if the independence of judiciary is to survive, we the judges also must accept our mistakes. One greatest example of institution accepting mistake, I must share with you. I'm sure some of you must have read that, especially senior members of the bar. It is again relating to Bombay High Court. As all of you know, Lokmanya Bar Gangadhar wrote 2 articles in one English newspaper and one Marathi newspaper, of which he was editor, and he was tried for sedition before Justice Dawar. At that time there was a jury trial, and he defended himself. So he was assisted by a large number of lawyers, defended himself. And I implore young members of bar to read his defense speech. When somebody is tried for sedition today, even today that speech is very relevant. That's not the point today. Point is that Justice Dawar convicted Lokmanya Bar Gangadhar clerk for transportation for 6 years. And then he was sent to Mandale. He underwent entire punishment British government did not release him, though during the period of incarceration his wife died. What happens in 1956 is very important. It was birth centenary of Lokmanya Bal Gangadhar Tilak. Chief Justice M.C. Shagla held a function in historic room number 46 where the trial of Lokmanya Bal Gangadhar Tilak was conducted. And he publicly apologized by saying that it was a grave mistake committed by Justice Dawar for convicting a great patriot and somebody who advocated very strongly for freedom of speech and expression. And therefore, if you visit room number 46, outside room number 46, those famous words of Lokmanya Bal Gangadhar Tilak have been described, when he said, when he was asked, when the jury said that by majority we hold that he is guilty, when Justice Dawar asked him, he said those magical words. He said that in spite of verdict of the jury, there are higher powers which rule the destiny of men and nations. And the cause which I represent may prosper more by my suffering than by my remaining free. So Justice M.C. Shagla and Chief Justice of Bombay High Court apologized to the citizens. Of course, as we have freedom of speech and expression, there were right-thinking people who criticized Justice Shagla. When High Court completed 100 years of its existence, one very eminent journalist who used to write about the judgments in Times of India and other leading newspapers was requested to write History of Bombay High Court. Those were the days when I also started practicing. Those were the days where the reports about the judgments delivered by the constitutional courts were not published on the same day. There were law reporters who used to go through the entire judgments. They used to cross-check all the references in the judgment, and after 2 or 3 days, they used to publish articles, very learned articles on the judgments. Now today, of course, when 10:30 Supreme Court pronounces the judgment, and our so-called experts are willing to discuss that judgment in the evening on television channel, where judgment runs into 4 or 5 different opinions and 1,000 pages. So that gentleman wrote a book in which he criticized Justice M.C. Shagla. He said Justice Shagla had no business to criticize Justice Dawar, because if you take into consideration the law which was prevailing at that time, Justice Dawar was fully justified in sentencing Lokmanya Tilak to undergo transportation. So these 2 events are very important. One, Chief Justice of Bombay High Court publicly apologizing, and the other, a fiercely independent journalist saying that Chief Justice is wrong. He did not say that Justice Dawar is right. He said that criticism is wrong. Now, gone are those days where there could be constructive criticism. One more fierce example of independence of a member of the bar, I remember. A judge of the Bombay High Court delivered certain lecture, a speech in one of the district places on the occasion of Lok Adalat. I am talking about way back 1986-87. Marathi version of Times of India wrote editorial severely criticizing that judge. It was purely constructive criticism. The editor referred to what the judge said and how he was wrong. And he also commented that when judge says something outside the court, he's just like any other ordinary citizen. And therefore he criticized. A division bench consisting of same judge or junior judge, they issued notice of criminal contempt to the editor. I was a very new lawyer, just joined the High Court practice after practicing for 2 or 3 years in district court. The Bombay Bar Association and Advocates Association of Western India, 2 very powerful associations. The Advocates Association of Western India, the oldest bar association in India, they decided to intervene. And 2 very formidable seniors were engaged to argue in favor of dropping the contempt. I don't recollect what were the arguments. I was fairly new. I was not conversant with nuances of law regarding contempt, but a team of about 10-11 over-enthusiastic juniors like me was constituted. And we were supposed to make research. Research was very difficult in those days because we had to go through all the commentaries, all the digests and the law reports. It was not on the fingertips. So arguments went on two senior advocates who were appointed by the Bar Association. They argued vehemently. Somehow bench was not convinced. Then came the turn of Advocate General. I'll tell who was the Advocate General. Advocate General was late Bhausai Bobde, father of Justice Bobde, former Chief Justice of India. And I could see exhibition of brilliant but fearless advocacy on his part. All the arguments were over. The judges asked, Mr. Advocate General, what do you have to say? And he had brilliant idea of advocacy. Sometimes he used to take strategic calls. He used to never respond immediately. So he just looked at the judges and then he said, Sir, I don't want to say many things. First thing which I want to say is, your lordship should not be touchy about the criticism made against you. Secondly, he said that, sir, I feel very sorry that a division bench of Bombay High Court is saying that such criticism is a contempt, when I expected the senior judges to uphold the right of the editor to write that article. Two sentences he uttered and he sat down. The bench assembled in the afternoon and they said that we have dropped the contempt proceedings. Very fearless way of advocacy. I can give you several instances of fearless advocacy. But now I want to be on the other part of it. Before I want to be on fairness on the part of the advocates. Before I do that, I want to tell you only one or two instances where really advocates went wrong. Now, first and foremost is tendency on the part of members of the bar of boycotting the courts. Though there are judgments of the Supreme Court which hold that boycotting the court amounts to criminal contempt, still those things happen. I want to tell you a practical part of it. Let us take the case of a district court where there are 10 courts. In 10 courts, there will be at least 50 cases listed. So if you boycott the court, 10 multiplied by 50, 500 cases are given dates, litigants go back. What a huge loss to the system. But still it happens. As a judge of the Bombay High Court, I had to issue contempt notices to about 8 to 10 bar associations. And they boycotted the court proceedings for months together in demand of setting of the bench. Unfortunately, this trend followed when I went to Karnataka. I had to issue notice to about 6 or 7 bar associations. Same thing is happening in Supreme Court. I had to issue notices to, I think, one of the bar associations for Rajasthan, Jaipur Bar Association. That 75 years of existence of Constitution, why this is happening. And keep aside the contempt part. I talked about ideals of the Constitution. One of the most important ideals is that justice should be made available. Justice, social, economic, and political. Now there can't be social and economic justice unless we are able to render quality justice to common man of this country. So whether judges, whether lawyers, all those who are part of legal system are duty bound to render justice to common man, justice to citizens of India. And if we are supposed to render justice, this boycott or skipping the court in protest does not find place in the Constitution at all. It is completely against the Constitution. One more instance which I had to deal with in Karnataka. There was a young student, some 20 years old, 21 years old. In one of the functions, one of the gatherings, she shouted something which people felt that it was anti-national. One or two sentences she said. She was taken into custody. She was a student of some undergraduate degree course. Shockingly, the local bar association passed a resolution that no lawyer will represent that particular girl. It was brought to my notice. I initiated suo motu contempt proceedings on the basis of the writ petition filed. The petition was filed before me by members of the bar. I told him that I am going to issue contempt notice to the Bar Association. But what manner you want to represent the cause? The members of the bar who were petitioners said, sir, we will go there and file a bail petition on behalf of that girl. They are all practicing in the High Court in Bangalore. I recorded that. They went to the court. The lawyers did not allow them to enter the court premises. Their cars were told to stop at a particular point of time. Then we had to pass an order, give them police protection. Let these lawyers go in police protection and file a bail petition. And eventually the bail petition was filed by those lawyers. So I admire the courage of those members of the bar who took up the cause against their own brother advocates in that particular district. Of course, later on, I issued contempt notice. The members of the bar apologized, they gave undertaking that they will never do it. I mean, this is completely against the ethos of our constitution. Can members of the bar say that a particular accused should not get a lawyer? This is completely in contravention of Article 21. But surprisingly, these are the things which happen. And as courts, sometimes we have to be very strong. We are not happy to issue contempt notices to the members of the bar. But unless we take that extreme step, we won't be able to enforce the obligations of the members of the bar under our constitution. Now, coming to the professional ethics, I consider myself to be very fortunate that there were senior members of the bar around me when I started practicing, from whom, without telling me what fairness means, I could learn the lessons of fairness. As a junior lawyer, a client came to me. He was owner of a vehicle involved in the accident, and it was a claim petition filed under the Motor Vehicles Act. And the injured had suffered fracture of 2 bones of his left leg, and the length of the leg was shortened because of that. There were medical certificates, and he was limping. That was very, very clear. Now, actually, my job was very simple because the claim was covered by insurance company. So therefore, I had a free hand. I mean, it's a process of learning to cross-examine. I started cross-examining. I gave a suggestion that I put it to you that you have not suffered any disability whatsoever. So one senior member of the bar was sitting there. Afternoon he called me. He said, never do that. You are also a human being. You know that this man has suffered disability. Your cross-examination should be to bring on record the percentage of disability. If he has claimed that he has suffered 50% disability, consider it on showing to the court it may not be 50%, it may be less than 50%. But don't be so inhuman. When you know that this man is limping, and don't give him suggestion that you are not suffering any disability. One more classic case. We had a very renowned lawyer practicing on the appellate side of the Bombay High Court. He was known for his fairness, and he was so fair. In those days, even in my practice days, second appeal, is very important litigation for all of us. Litigation of common man. So his reputation was, unless he himself was convinced that there was a substantial question of law involved, he would never argue a second appeal. He used to file it and stand up before the court. And his reputation was so high that some judges found that this lawyer utters 1 or 2 sentences, they used to just frame substantial question of law and admit appeals. That was his reputation. So I was a junior member of the bar. I had not argued a second appeal. So I reached the bar room where I used to sit. I received a call from my senior. In those days, mobile phones were not there. The bar association officer, I received a call. He said that he was feeling very unwell. He has fever. And he said that he has told 2 other juniors to mention matters for adjournment, but there is one second appeal before a very great judge of Bombay High Court. And we are respondents, so go ahead and argue that appeal. But I said, sir, I don't have the file. He said, no, file is there on my table. I think it is down below in the cause list, so go ahead and read the matter. So I took out that file, was sitting in the court waiting for my turn to come. The senior lawyer whom I referred, very fair lawyer, I was not aware that he is so fair. He was sitting next to me. In those days, Bombay High Court, there was no air conditioning. And because of sudden pressure, I was really perspiring. I never knew how to argue second appeal. I was just glancing through pages. So then suddenly I remembered that it was some issue regarding Hindu law. And we had that beautiful law report, Bombay Law Reporter. So there was one old judgment of 1929 or 30 on some issue of Hindu law. I forget what was the issue. So I thought that the judgment will apply. So I rushed to the library. I got the book. I gave a citation to the court Sirastedar, so that he could call book from the judge's library. So I was sitting there, wiping my face. The senior lawyer was sitting, he was supposed to have to happen, and he said, "Hey, young man, can I see that book?" I thought that this is my trump card and my opponent wants me to see that book. I reluctantly handed over the book. And then ultimately case was called out. He told judge, Justice S.K. Desai, very, very tough judge. Juniors had to be very well prepared to appear before him. He said, "Sir, I must tell you that this issue is squarely covered against me by judgment of our court, and fortunately this young man is carrying that judgment with him." Matter was over within 2 minutes. When we came out in the corridor, he said, "Arey, I know what must be passing in your mind, that you had trump card in your hand. I took that book for a different reason. I wanted to ensure that you have got the correct judgment." So that was the standard of fairness. See, ultimately, for the benefit of young members of the bar, I want to divulge one secret. See, when we sit on the dais, we are very lonely, and we prefer fair lawyers because we want that kind of assurance. So perhaps fair lawyers get better hearing in our courts. We want a lawyer who will tell us that, "Sir, prima facie, the issue which I am conversing is covered by judgment of this court, but I want to distinguish that judgment." So a fair lawyer is always welcomed by the judges. And why this fairness? Why fairness is required? The fairness is required for the simple reason that lawyers are integral part of our justice delivery system. And it is because of the lawyers that we are able to lay down the correct law. It is duty of the lawyer to ensure that justice is done in accordance with law. And fairness is required for one more reason. That as a lawyer, you have to be honest to the court. And therefore, if some facts are against you, please point out to the judge what is against you. And then argue that these facts will not ultimately affect the final decision. If all of us want to ensure that common man gets justice, common man will not get justice unless the lawyers are very fair. And I always believe that fairness pays in the long run. Maybe sometimes you will feel that because you are fair, you lost a case. But in the longer run, it will pay. How the mind of judge works, we know a lawyer, a fair lawyer appears before us, a young lawyer. He says, "Sir, this is covered. Prima facie, this is covered against me by judgment." Then the lawyer would try to distinguish. Then we as judges, we are also human beings. And our mind will also work to find out whether there is some way out. This man is very fairly telling that his case is covered against him. Then we also try to find out some way out, whether some limited relief can be granted, notwithstanding a binding judgment. So fairness always pays. One more part of advocacy on which I think I must elaborate. I think the members of the bar are now forgetting that brevity is hallmark of great advocacy. Of course, that is applicable to judges also. That our judgments must have quality of brevity. That applies to judges also. Both sides, perhaps we are forgetting the importance of brevity. The pleading pleadings. It starts with pleadings. Now pleadings have to be very precise. Maybe when I started practicing, our seniors expected us to write down, to make a written draft of plaint or written statement or a petition under Article 227. And when you write it down by hand, you have to be brief and precise. You can't keep on writing pages after the pages. In fact, I remember as junior lawyers, our seniors used to prohibit us from dictating a draft to a stenographer. They always felt that we must write it down. But now, technology is very useful in our justice delivery system, but technology sometimes can be harmful. Now we do cutting and pasting job by drafting a plaint or drafting a petition. Therefore, our pleadings become very verbose. The law is very clear that you should never plead law, but we plead law. In the counter affidavits filed before the High Court, now we cite judgments, we quote the paragraphs of the judgment. So the quality of brevity we are forgetting. And this tendency to cite large number of precedents, because they are available now. If there is a direct judgment of the Supreme Court on a particular issue, why you need to cite 4 or 5 judgments of the parent High Court on the same issue, or 10 judgments of other High Courts on the same issue? What is happening is now there is some kind of a competition. People want to show to the litigant that how much effort he has put in, and therefore the moment case is called out, especially in High Court and Supreme Court, he would hand over a compilation of judgments just to show that he is very well prepared. That is harming the judicial system. In fact, one of the judgments under Arbitration Act, I said something about arbitration that will apply to many other category of cases. I said that in India, arbitrations have become synonymous with verbose pleadings, verbose arguments, lengthy awards and lengthy judgments. It is true that we the judges also have forgotten to some extent that brevity is hallmark of a great justice. But sometimes why lengthy judgments are required to be written? If you go and argue an appeal before a district judge and place before him some 20, 25, 30 decisions, the judgment becomes lengthy because he has to refer to all the judgments. Where a district judge will always feel that somebody will find fault. In High Court, same lawyer will get up and say, sir, I cited about 25 decisions, but the judge has not referred to it. Therefore, there is a tendency to write long judgments. Now, this is one area where I think we are going wrong. Some of the amendments to the law also have contributed to it. Classic example, I tell you, the amendment to Order 18. When in civil courts, now we are permitted to file affidavits in lieu of examination in chief. When such affidavits are filed, when I read such affidavits, I always apply my mind and possibly imagine what would have happened if the witness would have, his evidence would have been recorded, examination chief would have been recorded in the open court. Now, because we are permitted to file affidavits, we file very bulky affidavits in lieu of examination chief, turning into pages. In city like Bombay and many metropolitan cities, it happens in section 138 complaints. There also there is an amendment. The affidavit in lieu of examination chief of complaint can be filed. Now sometimes the complaint runs into 10 pages, but affidavit in lieu of examination chief of complaint runs into 30 pages, 40 pages. So this is one provision of filing affidavits in lieu of examination chief is turning out to be counterproductive. I am not finding fault with the legislature. I am finding fault with those who are implementing it. When we judges also, we must be also telling the lawyers that this is not done. Why want very lengthy affidavits in lieu of examination chief? Now these are the simple causes for prolonging the trials. One more area where now we find, especially in criminal cases, there is very, very lengthy cross-examination. In November or December, we came across a case where we found that a defense lawyer had cross-examined a witness, say for half an hour or 1 hour every day, for 95 days, 95 different dates. And the cross-examination ran into some 55, 60 pages. And when we read the cross-examination, we found that there hardly anything relevant. The art of cross-examination is a forgotten art now. Now, what is happening in criminal trials is every sentence which is uttered in examination chief, the cross-examiner will say, I put it to you that this is wrong or this is false. It's not necessary. And in this lengthy cross-examination, the basic cross-examination about bringing on record the contradictions and omissions, we forget that. Or sometimes the cross-examination is so bulky, in the Supreme Court it takes time to find out which is the relevant part. Which is the relevant part where his witness is confronted with his prior statements and omissions and contradictions are brought on record. So therefore, when it comes to the professional ethics, the fairness is the most integral part of the professional ethics. And I want to again tell, for the sake of repetition, for benefit of young members of bar, that fairness always pays. Therefore, to conclude, professional ethics is not something which is written in the rules framed by the Bar Council and the State Bar Council or Bar Council of India. These rules are essential for ensuring that the lawyers are able to contribute to the justice delivery system. Because only if you follow the rules of ethics very strictly, in that case, you will be able to assist the court very effectively. All the great judgments, brother talked about Keshavananda Bharati. But for effort made by the lawyers, you would not have got those judgments. I give an example of emergency. In so many states, very distinguished lawyers filed petitions of habeas corpus for challenging the detention under that old act NISA. They succeeded or they failed, that's a different thing. But they showed highest degree of professional ethics and professional commitment and took up the causes. And last thing, my appeal to all young members of the bar is to work pro bono in legal aid cases. It's very, very important that all of you take up the legal aid cases. In fact, other day I was speaking to a gathering of lawyers in Bangalore. I said now time has come when we should make it compulsory for every designated senior advocate practicing in the High Court to appear at least in 5 criminal appeals where the accused cannot afford to engage a lawyer. 5 criminal appeals per year. And same rule should apply to the senior lawyers appearing in our trial courts, that they must do some pro bono work. There are many serious cases on the criminal side where perhaps junior and inexperienced lawyer appears and there is no proper cross-examination. And ultimately, if there is no proper cross-examination, it affects the right of the accused under Article 21. I always believe that legal practice is a 5-star social work, in the sense that if you are successful, you can earn a lot by practicing before the courts, but at the same time, you can do a lot of pro bono work and help poor people to agitate their grievances before the court. The last thing, I am really glad that Assam unit of Indian Law Institute is working efficiently, because in most of the states, the units of Indian Law Institute have become defunct. I just want to give one suggestion. Maharashtra Bar Council of Maharashtra and Goa, they conduct training courses for junior lawyers. That is known as CLEP, Continuous Legal Education Program. Now, the chapter of Indian Law Institute can start conducting such courses for junior lawyers, for beginners, the junior lawyers, where they need legal education. They need to be told the few concepts of art of advocacy. We must train them how to draft pleadings, how to conduct themselves in the court. We need to train them in basic discipline that when one lawyer is arguing, he is not supposed to interrupt. He has to show a lot of patience in the court. So, through the medium of Indian Law Institute, we can start training courses for young lawyers. Fortunately, in our country, and I'm sure about state of Assam also, there are many distinguished retired judicial officers, senior lawyers who will be willing to teach the young lawyers. So I thank the organizers for giving me this opportunity to have dialogue with all of you. So many young lawyers are standing here. I'm really glad that they have come in such large numbers. And especially to young members of the bar, I wish a great success. And I hope and trust that you will become instruments of change and you will be able to render quality justice to common man. Thank you.